The execution took place at dawn on March 23rd, 1946, in a small courtyard behind the military barracks of Lille in northern France. The condemned man was Henri Deschamps, a railway worker, 42 years old, father of 3 children. He stood against a wall pockmarked with bullet holes from previous executions, his hands tied behind his back, his eyes covered with a black cloth. A firing squad of 8 soldiers raised their rifles. The officer in command gave the order. The volley echoed through the morning mist. Henri Deschamps fell. He had been convicted of treason against France, sentenced to death by a military tribunal, and executed within 72 hours of his arrest. His crime? He had given food to a German soldier during the occupation. A single act of human compassion that the military court deemed collaboration with the enemy. But here is where the story becomes incomprehensible, where justice reveals its darkest face. 3 months after the execution, when Henri Deschamps was already buried in an unmarked grave, when his widow and children had been evicted from their home and branded as traitors, a military lawyer named Bernard Leclerc discovered something extraordinary. He found buried in the archives of the Ministry of Justice a circular dated August 1944, 2 years before Deschamps' execution. This circular, signed by the Provisional Government of Liberated France, explicitly stated that humanitarian acts toward enemy soldiers, when performed without strategic intent, should not be considered collaboration and should be prosecuted, if at all, under civilian law with proportionate sentencing. The circular further stipulated that any case involving such acts must be reviewed by a civilian prosecutor before military proceedings could begin. This review never happened in Deschamps' case. The military tribunal that condemned him to death either never knew of this circular or deliberately ignored it. How was this possible? How could a man be executed for a crime that, according to the law of his own government, should never have resulted in a death sentence? Perhaps should never have been prosecuted at all? How could a document that could have saved his life remain buried while he faced the firing squad? This is not a story about the fog of war or administrative error. This is a story about deliberate injustice, about a legal system weaponized against the powerless, about how law itself can become an instrument of murder when those who wield it choose convenience over truth. Bernard Leclerc was 37 years old when he stumbled upon the Deschamps case. He had spent the war years in London, working with the Free French Legal Services, drafting the framework for post-liberation justice. He returned to France in 1945 with idealistic visions of a new legal order, one that would balance accountability for collaboration with mercy for those caught in impossible circumstances. He believed that France could emerge from the darkness of occupation with its conscience intact. Within 6 months of his return, he understood how naive he had been. Leclerc had not been looking for the Deschamps case specifically. He had been assigned to review the records of military tribunals in the northern districts, a bureaucratic task meant to compile statistics for the government's official history of the liberation. He was reading through execution orders, one after another, each a brief summary of charges, evidence, verdict, sentence. Most followed predictable patterns: denunciation of resistance members, active collaboration with Gestapo, participation in deportations. Then he came to the file of Henri Deschamps. The charge sheet was unusually thin. The evidence consisted of a single witness statement from a neighbor, claiming to have seen Deschamps give bread and cheese to a German soldier in September 1944, during the final days of occupation. There was no evidence of repeated acts, no suggestion of payment or coercion, no claim that intelligence had been exchanged. Just food given to a hungry young man in Wehrmacht uniform. Leclerc sat in his office on Rue Saint-Dominique, the file open before him, the winter light fading through the window. Something felt wrong. He had reviewed hundreds of collaboration cases. They fell into categories: the war profiteers who sold to the Germans and became rich, the ideological collaborators who believed in fascism, the informers who sent neighbors to their deaths. Then, there were the gray cases, people who had worked in German offices or factories, who had done what they needed to survive. Those cases were complicated but comprehensible. The Deschamps case was different. It was too simple, too stark. A man executed for an act of basic humanity. Leclerc felt a cold certainty settling in his chest. This was wrong. Not just morally wrong, but legally wrong. There had to be something in the law that protected someone like Deschamps. There had to be. He began his search that evening. The law library at the Ministry of Justice was housed in a building that had survived the war intact, its shelves lined with leather-bound volumes of statutes, decrees, and judicial interpretations dating back to Napoleon. Leclerc started with the most obvious sources. The decree of August 26, 1944, which established the legal framework for prosecuting collaboration. He read it carefully, making notes. The decree defined collaboration broadly, encompassing any act that provided aid or comfort to the enemy. But it also contained a crucial clause, one that required prosecutors to consider intent and proportionality. An act performed under duress or without hostile intent toward France should be prosecuted as a misdemeanor under civilian jurisdiction, not as treason under military law. This clause seemed directly applicable to Deschamps. Why hadn't his tribunal considered it? Leclerc pulled more documents, circulars from the Ministry of Justice to regional prosecutors, internal memoranda from military legal offices. He worked through the night, the library slowly emptying around him until he was alone with the volumes and the silence. At 3 a.m, he found it. A circular dated August 31st, 1944, reference number J44-872. It was tucked into a folder of routine administrative correspondence, easy to miss unless you were looking carefully. The circular was brief, only 2 pages, but its content was explosive. It explicitly addressed cases like Deschamps. It stated that humanitarian acts toward enemy soldiers, including the provision of food or shelter, performed without intent to aid the enemy militarily or to harm France, should not be prosecuted as collaboration. If such cases were brought to trial, they must be heard in civilian courts, not military tribunals, and the maximum sentence should be imprisonment, not death. Leclerc read the circular 3 times, his heart pounding. This document should have saved Henri Deschamps. It was issued 2 years before his trial. It was legally binding on all prosecutors and military judges. Yet the tribunal in Lille had either never received it or had chosen to ignore it. Leclerc checked the distribution list attached to the circular. It included the military legal office in Lille. They had received it. They knew, and they had proceeded with the execution anyway. The question that haunted Leclerc as he walked home through the empty streets of Paris, the circular folded in his pocket, was simple but terrible. If this had happened to Henri Deschamps, how many others had died because of legal documents that were filed away and forgotten? How many executions had been carried out in violation of the government's own directives? Was Deschamps an isolated case, a tragic mistake, or was he one victim among hundreds, perhaps thousands, caught in a system that valued expedience over justice? Leclerc knew that pursuing this question would make him enemies. The liberation tribunals had been politically sensitive from the start. The government was under pressure from both sides. The resistance demanded harsh punishment for collaborators. The general public, exhausted by war, wanted to move on. The tribunals had walked a tightrope, trying to satisfy both demands while processing tens of thousands of cases as quickly as possible. Leclerc understood this. He had been part of the system's design. But understanding the pressures did not excuse the result. The law was supposed to be a shield, not a weapon. When it became a weapon, when it was used to kill a man who should have been protected, someone had to answer for it. But Leclerc faced a more immediate problem. He was alone. He had no official mandate to investigate the Deschamps case. His assignment was to compile statistics, not to question verdicts. If he raised this issue publicly, He would be seen as attacking the liberation government, as undermining public confidence in the purge of collaborators. His career, perhaps his freedom, would be at risk. The smart thing to do was to file his report, note the case as an anomaly, and move on. Leclerc considered this option for approximately 10 seconds. Then, he dismissed it. Henri Deschamps had been murdered by the state. That was what this was. Not an execution. A murder. And Leclerc was not going to let it rest. The next morning, Leclerc went to see his supervisor, Claude Moreau, the deputy director of legal affairs at the Ministry of Justice. Moreau was a career civil servant, shrewd and cautious, a man who had survived multiple regime changes by never committing too firmly to any political position. Leclerc laid out the Deschamps case, presenting the circular and explaining its implications. Moreau listened in silence, his face carefully neutral. When Leclerc finished, Moreau was quiet for a long moment, his fingers steepled under his chin. Then he spoke. "Bernard, I understand your concern. This is indeed troubling. However, we must consider the context. 1946 was a chaotic time. The tribunals were overwhelmed. Documents were misplaced. Communications broke down. It is unfortunate that this circular did not reach the judges in Lille in time. But these things happen in the aftermath of war." Leclerc felt anger rising in his throat. The circular was sent to Lille in August 1944. Deschamps was executed in March 1946. That's 18 months. This wasn't a matter of timing. They had the circular. They ignored it. Moreau's expression hardened slightly. "You don't know that. You're speculating. Perhaps the circular was filed incorrectly. Perhaps the judges never saw it. There could be many explanations." "Then we should investigate," Leclerc said. "We should review all the cases from that tribunal. If this happened once, it could have happened multiple times." Moreau shook his head. "That would require reopening hundreds of cases. It would cast doubt on the entire purge process. The political consequences would be severe. We cannot afford that kind of instability right now." "So we do nothing?" Leclerc's voice was sharp. "We let this stand?" "We learn from it," Moreau said firmly. "We ensure better procedures going forward. But we do not tear apart the past when the nation is trying to heal. That is my decision, Bernard. I expect you to respect it." Leclerc left Moreau's office knowing that he would get no support from the ministry. If he wanted justice for Henri Deschamps, he would have to pursue it alone, outside official channels. That meant going to the one place where the dead could still speak, where the voices of the executed could demand answers. He would go to Deschamps' widow. He would tell her what he had found. And together, they would bring this case back from the grave. Simone Deschamps lived in a narrow apartment on the outskirts of Lille, in a building that had been damaged during the liberation fighting and poorly repaired. The structure leaned slightly to one side, as if it were tired and ready to give up. The exterior walls were pockmarked with bullet holes, and several windows on the lower floors were still boarded up with rough planks. It was the kind of building where people lived when they had no other choice, when poverty or circumstance or social stigma had pushed them to the margins. Leclerc traveled north by train, carrying the circular and his notes in a leather satchel that had belonged to his father. The train was crowded and slow, stopping at every small station along the way. He sat by the window watching the landscape roll past, the flat fields and scattered farms, the occasional ruin of a bombed-out building, its walls standing like broken teeth against the sky. He had written to Madame Deschamps, asking for a meeting, explaining that he was investigating her husband's case, but had received no reply. He was not surprised. The widows of executed collaborators lived in a twilight world of stigma and suspicion. Many changed their names, moved to new cities, tried to erase any connection to the past. Those who remained faced daily humiliation. Their children were ostracized at school, taunted and beaten by classmates whose parents had been in the resistance. Employers refused to hire them. Landlords refused to rent to them. Neighbors whispered and pointed. To approach such a woman with questions about her husband's case was to risk rejection, anger, or worse. Leclerc climbed the stairs to the third floor, the steps creaking under his weight, the stairwell smelling of boiled cabbage and damp plaster. The walls were stained with moisture, and the paint was peeling in long strips. He found the door to Simone's apartment, a cheap wooden panel with a brass number that hung slightly crooked. He knocked, the sound echoing in the narrow hallway. He heard movement inside, footsteps approaching slowly, cautiously. Then, silence. He could sense someone standing on the other side of the door, listening, weighing whether to open it. He knocked again, more gently this time. A woman's voice came through the door, cautious, wary, roughened by years of hardship. "Who is it?" "My name is Bernard Leclerc. I'm a lawyer with the Ministry of Justice. I'd like to speak with you about your husband's case." The silence stretched out, longer this time. Leclerc waited, his breath visible in the cold air of the hallway. A dog was barking somewhere in the building, a repetitive, desperate sound. Finally, the door opened a crack, the chain still attached. Simone Deschamps looked out at him. She was in her late 30s, but looked older, worn down by grief and struggle. Her face was thin, almost gaunt, with deep lines around her mouth and eyes. Her hair, once probably thick and lustrous, was now streaked with gray and pulled back in a severe bun. But her eyes were sharp, intelligent, searching Leclerc's face for signs of threat or deception. She studied him for a long moment, taking in his worn suit, his serious expression, the leather satchel he carried. "You want to speak about Henri?" "Yes, madame. I believe there may have been a legal error in his case. A significant error. I'd like to discuss it with you." Simone's expression shifted, something hard and bitter crossing her features, a flash of the rage that must burn beneath her careful composure. "A legal error? Is that what you call it? They killed my husband for giving food to a boy who was starving. They took him away in the night and shot him like a dog. They destroyed my family. And you stand here on my doorstep and call it an error?" Leclerc met her gaze steadily, not looking away from the pain and anger in her eyes. "Madame, please. I'm not here to defend what happened. I'm not here to make excuses or to minimize what was done to you and your family. I'm here because I think it was wrong. I think the tribunal that sentenced your husband violated the law when they did so. I want to help you challenge the verdict. I want to help you clear his name." Simone stared at him for a long moment, her jaw tight, her hands gripping the edge of the door, as if she needed something to hold on to. Then, slowly, she stepped back and unlatched the chain. The door opened wider. "Come in." The apartment was sparse, furnished with the bare minimum that survival required. A small table with two mismatched chairs, their wood scratched and worn. A couch with faded upholstery, the springs visible through tears in the fabric. The walls were bare except for a single photograph of Henri Deschamps in a simple wooden frame, hung at eye level where Simone would see it every time she entered the room. His face was serious in the photograph, his eyes kind and gentle, his mouth set in a line that suggested both determination and vulnerability. He wore a dark suit, probably borrowed for the occasion, and his hair was carefully combed. It was the portrait of a working man trying to look his best, a man who took pride in his appearance, even though he had little. The floor was swept clean, but the boards were uneven, and some were starting to rot, where dampness had seeped through from below. A small window looked out onto a narrow courtyard, where laundry hung on lines between the buildings, gray shirts and worn dresses barely moving in the still air. The room was cold, heated only by a small iron stove in one corner that gave off barely enough warmth to take the edge off the winter chill. Simone gestured for Leclerc to sit at the table, then sat across from him, her hands folded in her lap, her posture rigid with tension that came from years of being on guard, years of expecting the worst from every encounter. Her nails were cracked and stained from whatever work she was doing now to keep herself and her children alive. Her dress was patched in several places, the repairs done carefully but visibly. She was a woman who had once had some measure of comfort, some security, and had lost it all. Everything about her spoke of endurance, of a determination to survive, despite circumstances that would have broken many people. Leclerc began carefully explaining what he had found, showing her the circular, describing its implications. Simone listened without interrupting, her eyes fixed on his face. When he finished, she was silent for a long time. Then she spoke, her voice barely above a whisper. "Why are you doing this? Why now? Henri is dead. Nothing you find will bring him back." "No," Leclerc agreed. "Nothing will bring him back. But we can clear his name. We can prove that his conviction was unlawful. We can ensure that his execution is recognized as an injustice. That matters, madame. Not just for Henri's memory, but for you and your children. You've been living under the shadow of his conviction. If we can overturn it, that shadow lifts." Simone looked at the photograph of her husband, her eyes filling with tears. "They destroyed us," she said quietly. "After they killed Henri, they took everything. The railway company fired me from my job. The school expelled my son. We had to move here, to this place, because our neighbors made our lives impossible. Every day, someone reminds us that we are the family of a traitor. My daughter changed her name so she could find work. She won't speak to me anymore because being associated with me costs her too much." She turned back to Leclerc, her expression fierce. "So yes, Monsieur Leclerc, I want his name cleared. I want the world to know that Henri Deschamps was not a traitor. He was a good man who made one mistake, showing kindness when kindness was forbidden. If you can do that, if you can prove that they murdered him, then I will help you in any way I can." Leclerc felt a surge of determination. "Then we need to understand exactly what happened at his trial. Do you have any records? Any documents from the proceedings?" Simone shook her head. "They gave me nothing. No transcript, no verdict document, nothing. They came to my door 3 days after his arrest and told me he had been executed. That was all." "What about a lawyer? Did Henri have legal representation?" "They said he did. A military lawyer. But I never met him. Henri never mentioned his name. I don't think the lawyer did anything." Leclerc made a note. This was not uncommon. Military tribunals in the immediate post-liberation period often provided only perfunctory legal defense, especially in collaboration cases where the verdict seemed predetermined. But it meant that reconstructing the trial would be difficult. Without a transcript, without witness statements, Leclerc would have to piece together what happened from fragmentary records and the memories of those involved. "I need to go to the military archive in Lille," Leclerc said. "They should have the tribunal's records. The charge sheet, the verdict, the execution order, anything that documents what happened. And I need to find the judges who heard the case. They need to answer questions about why they ignored the circular." Simone leaned forward. "They won't talk to you. They'll close ranks. They'll say it was wartime, that mistakes were made, that it's all in the past. I've seen how this works. The powerful protect each other. The dead are convenient scapegoats. Henri can't defend himself, so they'll make him responsible for his own execution." "Maybe," Leclerc said, "but we're going to make it very difficult for them. We're going to shine a light on every detail of this case. We're going to make it impossible for them to hide behind vague excuses. And if they refuse to answer, that refusal itself will tell us something important." Simone studied him, her expression softening slightly. "You really believe you can do this? You really believe you can get justice for Henri?" "I believe I have to try," Leclerc said. "I can't promise victory, madame. I can't promise we'll succeed. But I can promise that I will not stop until I've done everything possible. Henri Deschamps deserves that much. And so do you." The military archive in Lille was housed in the basement of the regional headquarters, a sprawling building that had served as a German command center during the occupation and been hastily repurposed after liberation. Leclerc arrived on a gray morning in late February, the wind carrying the smell of rain and coal smoke from the factories that lined the outskirts of the city. The building itself was forbidding, its facade scarred with shrapnel marks that no one had bothered to repair, as if the wounds of war were meant to remain visible, a permanent reminder of what had been endured. The archive was managed by a sergeant named Dubois, a middle-aged man with a perpetual expression of irritation, as if the very existence of records and their maintenance was a personal affront to his dignity. Leclerc presented his credentials and explained what he needed. Dubois listened with obvious reluctance, examining Leclerc's identification card with suspicious eyes, as if looking for some irregularity that would allow him to refuse the request. Then he shrugged, a gesture of resignation rather than cooperation. Collaboration cases from 1946? There are thousands. You'll have to look through them yourself. I don't have time to help you. I'm looking for one specific case. Henri Deschamps, executed March 23rd, 1946. Dubois scratched his chin, considering. His fingers were stained with ink, and his nails were cracked and dirty. March 1946. That would be in box 47 or 48. This way. He led Leclerc down a narrow corridor lined with metal shelves, each stacked with gray cardboard boxes that sagged under their own weight. The air was damp and cold, thick with the smell of mildew and old paper and something else, something metallic and vaguely unpleasant that Leclerc could not identify. Perhaps it was the smell of rust from the shelving, or perhaps it was something deeper, the accumulated residue of death and bureaucracy, the documents of thousands of destroyed lives slowly decomposing in the darkness. The corridor was lit by bare bulbs that cast harsh shadows, making the space feel claustrophobic and oppressive. Leclerc's footsteps echoed on the concrete floor, each step a hollow sound that seemed to emphasize his isolation, his distance from the world of light and air above. Dubois stopped at a shelf near the back, pulled down 2 boxes with a grunt of effort, and set them on a wooden table that wobbled on uneven legs. The boxes were heavy, their cardboard softened by moisture, and they left marks in the dust that coated every surface. These are the execution cases from March. Look through them. If you need copies, I'll charge you the standard rate, 2 francs per page. Leclerc thanked him and began his search. The boxes contained hundreds of files, each a thin folder with a name, a case number, and a brief summary of charges and verdict. The folders were arranged chronologically but without much care, some upside down, others bent or torn at the edges. The paper had yellowed and become brittle, and Leclerc handled each file carefully, afraid that rough treatment might cause it to disintegrate in his hands. He worked methodically, reading each one, setting aside those that seemed potentially relevant. The cases blurred together after a while, a monotonous litany of human tragedy. Denunciations of resistance members, black market operations that had enriched some and starved others, forced labor in German factories, military service for the Waffen-SS. Each folder represented a life destroyed, a family shattered, a person who had made choices or been forced into choices that led them to a courtyard with a firing squad or a prison cell. The cumulative weight of it was crushing. Leclerc found himself having to stop periodically, to stand and walk around the table, to take deep breaths of the cold, stale air, trying to clear his mind of the images that the files conjured. After 2 hours, his eyes aching and his back stiff from bending over the table, he found it. Henri Deschamps. Case number 47-231. The folder was identical to all the others. Nothing to distinguish it, no mark or notation to indicate that this particular case was anything other than routine. But to Leclerc, holding it in his hands, it felt different. This was why he had come. This was the moment he had been working toward since that day in his office, when he had first read about Deschamps and felt the cold certainty that something was wrong. Leclerc opened the file with a sense of anticipation mixed with dread. His hands were trembling slightly, whether from cold or emotion he could not tell. The file was thin, less than 10 pages, lighter than it should have been for a case that ended in death. That itself was revealing. A thorough trial, a careful consideration of evidence, would have generated more paper. This was summary justice, justice reduced to its bureaucratic minimum. The charge sheet was typewritten on official military letterhead, the letters slightly faded, some struck harder than others, showing the uneven typing of someone working quickly, without care for appearance. It stated that Henri Deschamps, resident of Lille, 42 years of age, employed as a railway maintenance worker, had been observed providing food to a German soldier on or about September 15, 1944, in violation of Article 2 of the Decree of August 26, 1944, on collaboration with the enemy. The evidence consisted of a witness statement from one Marie Fournier, a neighbor of Deschamps, who claimed to have seen the act through her kitchen window at approximately 4:30 in the afternoon. Leclerc read the witness statement carefully. It was brief, barely half a page. Fournier stated that she had observed Deschamps approach a German soldier who was sitting on a low wall near the railway yard. The soldier appeared young and exhausted. Deschamps had given him a small package wrapped in cloth, which the soldier had opened and begun eating. The exchange lasted perhaps 2 minutes. Deschamps had then returned to his work. Fournier had reported this to the local resistance committee, which had forwarded the information to the military authorities after liberation. There was no evidence that Deschamps had received anything in return for the food. No evidence that any intelligence had been exchanged. No evidence of repeated contact or ongoing relationship. Just this single act, witnessed by a neighbor who had decided that compassion was indistinguishable from treason. The trial record was even more sparse. There was no transcript of testimony, no record of cross-examination, no indication that Deschamps had been allowed to call witnesses in his own defense or to present evidence of mitigating circumstances. The verdict was a single paragraph typed on the same uneven typewriter. Guilty of collaboration with the enemy through provision of material support. Sentence: death by firing squad, to be carried out at the earliest practicable date. The order was signed by 3 judges: Colonel André Masson, presiding officer; Major Luc Bertrand, associate judge; Captain François Duval, associate judge. The signatures were hasty, barely legible, as if the judges had been in a hurry to move on to the next case. Leclerc felt his pulse quicken, a physical sensation of anger rising through his chest and into his throat. Here it was, the formal record of the tribunal's decision, the document that had sealed Henri Deschamps' fate. But something was missing, something fundamental. There was no mention of the circular, no discussion of whether the act constituted humanitarian aid rather than collaboration, no consideration of proportionality or intent, no analysis of whether the act posed any real threat to France or provided any real benefit to Germany. The tribunal had treated this as a straightforward case of aiding the enemy, as if the circular that should have protected Deschamps did not exist, as if the legal framework that required consideration of intent and proportionality had never been written. Leclerc flipped through the remaining pages, hoping to find some notation, some acknowledgement that the tribunal had at least considered the legal framework. There was nothing. The file ended with the execution order, stamped and signed, dated March 23, 1946. Leclerc made copies of the entire file, paying Dubois the required fee, then left the archive with a growing sense of outrage. The tribunal had not simply made an error. They had conducted a trial without reference to the relevant law. Either they were incompetent, which seemed unlikely given their rank and experience, or they had deliberately chosen to ignore the circular because it would have complicated their work. Either way, Henri Deschamps had been denied even the minimal protections that French law afforded him. His execution was not just unjust, it was unlawful. But Leclerc needed more than the file. He needed to understand how the tribunal operated, how cases were assigned, how evidence was reviewed. He needed to know whether the circular had been distributed to the judges, whether they had access to it, whether there was any procedural mechanism that should have brought it to their attention. And most importantly, he needed to find the judges themselves. He needed to look them in the eye and ask them why they had sent a man to his death in violation of the law they were sworn to uphold. Finding Colonel André Masson proved surprisingly easy. He had retired from active service in 1948 and was now living in Paris, working as a consultant for the Ministry of Defense. Leclerc arranged a meeting, presenting himself as a legal researcher compiling a history of the liberation tribunals. Masson agreed to meet at a café near the Champ de Mars, suggesting they talk over coffee. Masson was in his early 60s, tall and lean, with a military bearing that had not diminished with age. He greeted Leclerc with a firm handshake and ordered coffee for both of them. They made small talk for a few minutes, discussing the weather and the state of French politics. Then, Leclerc steered the conversation to the tribunals. "I've been reviewing cases from the Lille tribunal," Leclerc said carefully. "You presided over a number of them in early 1946. Masson nodded. "Yes, it was difficult work. We processed hundreds of cases. The pressure was enormous. Everyone wanted swift justice. But justice is never swift when you're dealing with complex facts and ambiguous circumstances. One case in particular caught my attention," Leclerc said. "Henri Deschamps, executed in March 1946 for giving food to a German soldier." Masson's expression did not change, but Leclerc saw something flicker in his eyes. Recognition, perhaps, or wariness. "I don't recall the specific case," Masson said evenly. "There were so many." "The file is quite brief," Leclerc continued. "The evidence consisted of a single witness statement. The verdict was death. It seems like a harsh sentence for what appears to have been a minor act of misguided compassion." Masson set down his coffee cup, his gaze steady. "Monsieur Leclerc, I sense that you are not simply compiling a history. You have an agenda. Why don't you tell me what this is really about?" Leclerc met his gaze. "I'm trying to understand how a man could be executed for an act that, according to a government circular issued in August 1944, should not have been prosecuted as collaboration at all. I'm trying to understand how a tribunal could ignore the law and send a man to his death." Masson's face hardened. "You're accusing me of ignoring the law? I'm asking you whether you were aware of the circular, whether it was brought to your attention during Deschamps' trial, and if it was, why you chose to disregard it." Masson was silent for a long moment. When he spoke, his voice was cold. "I am not going to sit here and be interrogated about decisions I made 5 years ago under extraordinary circumstances. The tribunals operated in the immediate aftermath of occupation. We were dealing with chaos, with limited resources, with enormous pressure from the public and the government to act decisively. If mistakes were made, they were made in good faith." "Good faith?" Leclerc kept his voice level. "A man is dead because your tribunal did not follow the law. How is that good faith?" Masson stood abruptly. "This conversation is over. I suggest you be very careful, Monsieur Leclerc, about the accusations you make. There are consequences for attacking the reputation of men who served France during its darkest hour." He turned and walked out of the café, leaving Leclerc alone with 2 cups of coffee and the certainty that he had struck a nerve. The encounter with Masson confirmed what Leclerc had suspected. The judges knew about the circular. They knew, and they had chosen to ignore it. But knowing this and proving it were different things. Leclerc needed documentary evidence. He needed to show that the circular had been distributed to the Lille tribunal, that it was available to the judges, that they had no excuse for their ignorance. And he needed to understand why they had made that choice. Was it simply expedience, a desire to clear cases quickly? Or was there something more, a deliberate policy to treat certain cases harshly as a deterrent? Leclerc returned to Paris and began a systematic search through the administrative records of the military justice system. He spent weeks in archives, reading through distribution logs, internal memoranda, and judicial correspondence. The work was tedious, numbing, the kind of detailed forensic investigation that required endless patience and a willingness to sift through mountains of irrelevant material in search of a single crucial document. Leclerc found himself working late into the night, his eyes burning from reading faded typewritten pages, his back aching from hours bent over dusty files. And slowly, piece by piece, the picture emerged. The circular had been distributed to all regional military legal offices in September 1944, 1 month after it was issued. Leclerc found the distribution log, which showed that a copy had been sent to Lille on September 7th, 1944. He found a receipt signed by the chief legal officer in Lille, acknowledging receipt on September 10th. The circular had been filed in the office's legal reference library, where it should have been accessible to any judge preparing for a trial. But here Leclerc discovered something unexpected. A memorandum dated October 1944, sent from the regional military commander in Lille to all tribunal judges. The memorandum stated that, given the high volume of collaboration cases and the need for swift processing, tribunals should focus on clear violations of Article 2 of the Collaboration Decree and should avoid delays caused by consideration of mitigating factors or legal technicalities. The memorandum did not explicitly mention the circular, but its meaning was clear. Speed over precision, convictions over acquittals, the appearance of decisive justice over the reality of careful legal review. Leclerc read the memorandum 3 times, feeling a cold fury building in his chest. This was the explanation. The judges in Lille had been told, effectively, to ignore documents like the circular because they would slow down the process. Henri Deschamps had been executed not because the law demanded it, but because the system wanted efficiency. His life had been sacrificed to the machinery of mass punishment, to a process that valued throughput over truth. But Leclerc still needed one more piece. He needed to prove that this memorandum had influenced the Deschamps case specifically. He needed to show that the judges had been aware of both the circular and the memorandum, and had chosen to follow the memorandum's implicit instruction to disregard mitigating factors. This would be the hardest part. It required getting inside the judge's deliberations, understanding the reasoning that led to the death sentence. He decided to approach the other 2 judges, Major Bertrand and Captain Duval, hoping that one of them might be more forthcoming than Masson. Bertrand was still on active duty, stationed in Lyon. Leclerc traveled south, meeting him at his office. Bertrand was younger than Masson, in his mid-40s, with a nervous energy that suggested he was uncomfortable with the past. Leclerc explained his research, framing it as a historical project, avoiding direct accusations. Bertrand listened, nodding occasionally, his fingers drumming on the desk. When Leclerc mentioned the Deschamps case, Bertrand frowned. I remember that one. It bothered me at the time. The evidence was thin, the act seemed minor, but Masson was adamant. He said we needed to send a message, that any act of aid to the Germans, no matter how small, had to be punished harshly. Leclerc leaned forward. Did you discuss the circular? The one that exempted humanitarian acts from collaboration charges? Bertrand hesitated, his expression troubled. I mentioned it. I said we should consider it. Masson dismissed it. He said the circular was meant for cases where there was clear evidence of coercion or ignorance, not for someone who voluntarily gave aid to the enemy. He said we couldn't let ourselves be tied up in legal distinctions when the nation needed swift justice. And you went along with that? Bertrand's face flushed. What choice did I have? Masson was the presiding judge. He made the decisions. I was a junior officer. If I had dissented publicly, it would have destroyed my career. So you allowed a man to die because you were afraid for your career? Bertrand stood abruptly, his voice rising. Don't you dare judge me. You weren't there. You didn't see what we were dealing with. Thousands of cases, all of them complicated, all of them urgent. We did the best we could under impossible circumstances. If we made mistakes, we made them trying to protect France. Leclerc left Lyon with mixed feelings. Bertrand's admission was damning, but it was also pathetic. He had known the law, had seen the injustice, and had done nothing because he lacked the courage to stand up to Masson. He was complicit, but he was not the architect. Masson had made the decision. Masson had known about the circular and had chosen to ignore it, prioritizing speed and severity over legal accuracy. Masson was the one who bore ultimate responsibility for Henri Deschamps' death. But Leclerc still faced a formidable obstacle. He had testimony from Bertrand, but it was informal, given in a private conversation. Bertrand would never testify publicly. He would never risk his career by admitting in court that he had participated in an unlawful execution. Without his testimony, Leclerc's case rested on documents and inference. Compelling, perhaps, but not conclusive. He needed something more. He needed a smoking gun, a document that explicitly showed the judges had been aware of the circular and had deliberately disregarded it. Leclerc returned to Paris and resumed his search through the archives. He was looking now for internal communications within the Lille tribunal, notes or memoranda that might reveal the judge's reasoning. This material was not easily accessible. Tribunal records had been organized by case, not by judge, and internal communications were often destroyed or misfiled. Leclerc spent days requesting boxes from storage, sifting through miscellaneous correspondence, looking for anything related to the Deschamps case or to Masson's approach to collaboration trials. He found it on a Thursday afternoon in April 1951, 5 years after Henri Deschamps' execution. It was a handwritten note, barely a paragraph, scrawled on a piece of official letterhead. The note was from Masson to the chief legal officer in Lille, dated March 20th, 1946, 3 days before Deschamps' execution. It read, "Henri Deschamps case. I am aware of the circular regarding humanitarian acts. I do not believe it applies here. The Defendant's Act, while presented as compassion, represents a fundamental failure to recognize the enemy as the enemy. We cannot allow sentimentality to undermine the severity of collaboration charges. Recommend proceeding with execution as planned." Leclerc stared at the note, his hands trembling. This was it. This was the proof. Masson had known about the circular. He had explicitly acknowledged it, and he had decided to disregard it, not because he believed it was inapplicable, but because he thought applying it would undermine the harsh message he wanted to send. He had chosen to execute Henri Deschamps as a demonstration, as a warning to others. The execution was not a mistake or an oversight. It was a deliberate act of judicial murder. Leclerc made a copy of the note, handling it as if it were fragile, as if it might disintegrate in his hands. He left the archive feeling as if he had crossed a threshold. He now had everything he needed. The circular that should have protected Deschamps. The memorandum that encouraged judges to ignore such protections. Bertrand's admission that Masson had dismissed the circular. And now Masson's own handwritten note, explicitly acknowledging the circular and choosing to disregard it. The case was complete. The evidence was overwhelming. Henri Deschamps had been executed in violation of French law, and the judges who sentenced him had known exactly what they were doing. But knowing this and achieving justice were still two different things. Leclerc now faced the most difficult part of his quest. He needed to bring this evidence before a court. He needed to force the French legal system to confront what it had done, to acknowledge that one of its own tribunals had committed murder under the guise of law. And he needed to do this in a country that was desperately trying to move beyond the trauma of occupation, that wanted to forget the purges and the executions, that preferred silence over reckoning. Leclerc met with Simone Deschamps in her small apartment in Lille, spreading the documents across her kitchen table. She read through them slowly, her hands shaking, tears streaming down her face. When she finished, she looked up at Leclerc, her expression a mixture of grief and fury. "They knew," she whispered. "They knew he shouldn't have died, and they killed him. Anyway." "Yes," Leclerc said, "they knew. And now we can prove it. We can file for a posthumous review of his conviction. We can demand that the court overturn the verdict and officially exonerate Henri. We can force Masson and the others to answer for what they did." Simone wiped her eyes, her jaw set. "Do it. Whatever it takes, do it. I want the world to know what they did to my husband. I want his name cleared. I want justice." Leclerc filed the petition for review in June 1951. The petition was comprehensive, running to over 100 pages, meticulously documenting every aspect of the case. It included the circular that should have protected Henri Deschamps. the memorandum that encouraged judges to disregard such protections, Bertrand's informal admission, and, most devastatingly, Masson's handwritten note acknowledging the circular and choosing to ignore it. The petition argued that Deschamps' conviction and execution were unlawful under French law, that they violated basic principles of justice and proportionality, and that the tribunal had acted in bad faith. It requested that the court overturn the conviction, officially exonerate Deschamps, and refer the case to prosecutors for potential charges against the judges involved. The petition created an immediate furor. The press picked up the story, and within days, it was national news. Headlines screamed about judicial murder and legal injustice. The government, caught off guard, scrambled to respond. Officials issued statements defending the liberation tribunals, insisting that they had operated in good faith under difficult circumstances, that mistakes were inevitable in the chaos of post-war justice. But the evidence in Leclerc's petition was too strong, too detailed, to dismiss. Even sympathetic commentators acknowledged that something had gone terribly wrong in the Deschamps case. Masson, Bertrand, and Duval issued a joint statement through their lawyer, denying any wrongdoing and characterizing the petition as a politically motivated attack on men who had served France honorably. They argued that the circular was ambiguous, that its application to specific cases required judgment, and that their decision in the Deschamps case was within their discretion as judges. They further argued that reopening cases from the liberation tribunals would set a dangerous precedent, potentially calling into question thousands of convictions and destabilizing the legal foundations of post-war France. The court assigned the case to a 3-judge panel, headed by Justice René Marchand, a respected jurist known for his careful, methodical approach to complex legal questions. The hearing was scheduled for October 1951, giving both sides time to prepare their arguments. Leclerc worked around the clock, refining his legal reasoning, anticipating counter-arguments, preparing to present the most compelling case possible. The hearing took place on a cold, rainy morning in October. The courtroom was packed with journalists, legal observers, and members of the public. Simone Deschamps sat in the front row, her face pale but composed. Masson, Bertrand, and Duval sat on the other side, flanked by their lawyers, their expressions carefully neutral. Leclerc stood at the petitioner's table, his notes spread before him, feeling the weight of 5 years of work pressing down on him. Justice Marchand called the hearing to order. Leclerc rose to present his case. He began by outlining the facts, the act for which Henri Deschamps was convicted, the evidence against him, the severity of the sentence. Then he turned to the law, presenting the circular, reading its provisions aloud, emphasizing its clarity and its mandatory nature. He showed that the circular had been distributed to the Lille tribunal 18 months before Deschamps' trial. He presented the memorandum encouraging judges to disregard such protections in the interest of speed. He quoted Bertrand's admission that Masson had dismissed the circular. And then, in the most dramatic moment of the hearing, he presented Masson's handwritten note. Leclerc read the note slowly, clearly, letting each word land. I am aware of the circular regarding humanitarian acts. I do not believe it applies here. The defendant's act, while presented as compassion, represents a fundamental failure to recognize the enemy as the enemy. We cannot allow sentimentality to undermine the severity of collaboration charges. Recommend proceeding with execution as planned. The courtroom was silent. Leclerc looked up at the judges. This note proves beyond any doubt that Colonel Masson was aware of the circular. He knew it existed. He knew it was meant to protect people like Henri Deschamps. And he chose to ignore it, not because he believed it was inapplicable, but because he thought its application would undermine the message he wanted to send. He executed Henri Deschamps to make an example, to show that any act of aid to the Germans, no matter how minor, would be punished with death. That is not justice. That is murder. The defense attorney rose to respond. He argued that the circular was subject to interpretation, that Masson's judgment about its applicability was within his discretion as a judge, that the court should not second-guess decisions made under the extraordinary pressures of post-liberation justice. He argued that overturning Deschamps' conviction would open the floodgates to thousands of petitions, destabilizing the entire framework of post-war legal accountability. But Leclerc's rebuttal was devastating. He pointed out that the circular was not ambiguous. It explicitly exempted humanitarian acts from collaboration charges. There was no room for interpretation. Masson had not interpreted the circular differently. He had simply ignored it because it was inconvenient. And as for the argument about precedent, Leclerc argued that justice delayed is not justice denied when the alternative is to allow a state-sanctioned murder to stand unchallenged. If we are afraid to correct this injustice because it might require us to correct others, Leclerc said, then we are admitting that the law is not a shield, but a weapon, and that it serves not justice, but convenience. The judges retired to deliberate. The wait was agonizing. Hours passed. Leclerc sat with Simone Deschamps, neither of them speaking, both lost in their own thoughts. Finally, as evening fell, the judges returned. Justice Marchand read the decision. The court found that Henri Deschamps' conviction and execution were unlawful. The circular of August 1944 explicitly exempted humanitarian acts from collaboration charges when performed without strategic intent. The evidence showed that Deschamps' act fell within this exemption. The tribunal in Lille had been aware of the circular, but had chosen to disregard it, not because of any reasonable interpretation of the law, but because of a policy preference for harsh punishment. This was a violation of basic legal principles. The conviction was overturned. Henri Deschamps was officially exonerated. The court further recommended that the Ministry of Justice conduct a comprehensive review of all cases from the liberation tribunals to identify other potential miscarriages of justice. The courtroom erupted. Journalists rushed to file their stories. Simone Deschamps collapsed in tears, clutching Leclerc's arm. Masson and his co-defendants sat in stunned silence, their faces ashen. Leclerc felt a wave of exhaustion and relief wash over him. It was done. Henri Deschamps had been vindicated. The system had acknowledged its crime. Justice, imperfect and delayed, had been achieved. But the story did not end there. The court's decision had far-reaching consequences. The Ministry of Justice, under intense public pressure, launched a review of liberation tribunal cases. Over the next 2 years, investigators examined hundreds of files, looking for evidence of similar legal violations. They found dozens of cases where defendants had been convicted in violation of the circular or other protective provisions. Many of these convictions were overturned. The judges involved faced varying degrees of professional sanction, though none were criminally prosecuted. Masson resigned from his consulting position and retreated into private life, a broken man whose reputation was destroyed. The Deschamps case also had an impact on international law. Leclerc's petition and the court's decision were studied by legal scholars and cited in discussions about judicial accountability and the limits of judicial discretion. The principle that judges must follow the law even under extraordinary circumstances, that they cannot disregard legal protections because of policy preferences or political pressure, became a cornerstone of post-war human rights jurisprudence. The case was cited in the Geneva Conventions, in the Charter of the International Criminal Court, in countless legal textbooks and academic articles. Henri Deschamps, a railway worker who died for an act of kindness, became a symbol of the importance of legal integrity, of the need for laws to protect individuals even in the darkest times. For Simone Deschamps, the victory was bittersweet. Her husband was exonerated, his name cleared, but he was still dead. No court decision could bring him back. She lived the rest of her life in Lille, her children eventually reconciling with her as the stigma of Henri's conviction faded. She became an advocate for judicial reform, speaking at legal conferences and universities about the importance of legal protections and the dangers of expedient justice. She died in 1973, at the age of 64, surrounded by her family. Her last words, a quiet expression of gratitude to Bernard Leclerc for giving her husband back his name. Leclerc continued his work at the Ministry of Justice, eventually rising to a senior position. But the Deschamps case remained the defining achievement of his career. He spoke about it rarely, uncomfortable with the attention and the praise. For him, the case was not about heroism or courage. It was about duty. He had stumbled upon an injustice and had felt compelled to correct it. The fact that it had taken 5 years of his life, that it had cost him professionally and personally, was irrelevant. The law meant nothing if it did not protect those who needed protection most. Henri Deschamps had been one such person, and the law had failed him. Leclerc's work was simply to make that failure visible and to ensure that it was acknowledged. In the decades that followed, the Deschamps case became part of France's collective memory, a reminder of the moral complexities of the liberation period and the dangers of allowing justice to be subordinated to political expediency. School children learned about Henri Deschamps, about the man who died for giving food to the hungry. Law students studied the case, analyzing the legal principles it established. Journalists and historians wrote about it, using it as a lens to examine the broader questions of collaboration, punishment, and reconciliation in post-war Europe. But perhaps the most important legacy of the Deschamps case was the precedent it established for challenging state power through legal action. Leclerc had shown that even the most established institutions could be held accountable, that even the most powerful individuals could be forced to answer for their actions, that a single determined person, with the law on their side, could change the course of history. This lesson resonated far beyond France, inspiring lawyers and activists around the world to use legal mechanisms to fight injustice, to demand accountability, to insist that the law serve its highest purpose, the protection of human dignity. Today, more than 70 years after Henri Deschamps faced the firing squad, his story remains relevant. In courtrooms and legislatures, in academic conferences and human rights forums, his case is invoked as a cautionary tale about what happens when legal systems prioritize efficiency over justice, when judges allow themselves to be swayed by political pressure or personal bias, when the law becomes a tool of oppression rather than a shield for the vulnerable. The circular that should have saved his life is now enshrined in international human rights law, its principles incorporated into treaties and conventions that govern how nations treat individuals in times of crisis. And in a small cemetery on the outskirts of Lille, there is a gravestone that was once unmarked, but now bears an inscription. Henri Deschamps, born 1904, died 1946, wrongfully executed, officially exonerated 1951, a man of compassion in a time of cruelty. His death was an injustice. His vindication was a triumph of law over power. The stone was placed there by Simone Deschamps and Bernard Leclerc together on a spring morning in 1952. They stood side by side, neither speaking, both understanding that no words could adequately capture what the case had meant, what it had cost, what it had achieved. Henri Deschamps gave food to a hungry soldier. For this, he was killed. But his death was not in vain. It exposed a legal system that had lost its way, forcing it to confront its failures and to reform. It established principles that protect individuals from arbitrary state power. It showed that even in the darkest times, even when the machinery of justice has been corrupted, there's always the possibility of redemption, always the chance that someone will stand up and say, "This is wrong, and I will not let it stand." Bernard Leclerc was that person. And Henri Deschamps, through his death and his vindication, became a symbol that justice, however delayed, however difficult, is always worth fighting for. The story of Henri Deschamps is not just a historical curiosity. It is a living testament to the fragility of justice and the courage required to defend it. In every generation, in every country, there are Henri Deschamps cases waiting to be discovered, waiting for someone to shine a light on them, waiting for justice. And in every generation, there must be Bernard Leclercs, people willing to do the hard, lonely work of challenging power, of demanding accountability, of insisting that the law mean what it says, and protect those who need protection most. This is not a comfortable truth. It is not an easy calling, but it is a necessary one. Because without people like Bernard Leclerc, people willing to stand up and fight for the dead and the forgotten, the law becomes nothing more than words on paper, empty promises that the powerful can ignore whenever it suits them. Henri Deschamps was a railway worker, a husband, a father. He was not a hero or a martyr. He was simply a man who saw another human being in need and responded with kindness. For this, he was executed. And for this, he is remembered. Not because his death was unique or extraordinary, but because it revealed a fundamental truth about justice. Justice is not automatic. It does not happen on its own. It requires vigilance, effort, courage. It requires people like Bernard Leclerc, who are willing to spend years searching through archives, to risk their careers, to challenge the powerful, to refuse to accept injustice, simply because it is convenient or expedient to do so. This is the lesson of the Deschamps case. This is its enduring legacy. And this is why, more than 7 decades after Henri Deschamps fell before a firing squad, his story still matters. Because the battle for justice is never won once and for all. It must be fought again and again in every generation, in every context. And it can only be won by people who refuse to accept the comfortable lie that justice is someone else's responsibility, that the system will correct itself, that the past should be left alone. Justice is everyone's responsibility. The system does not correct itself, and the past, if left unexamined, will repeat itself. Henri Deschamps did not get justice in his lifetime, but he got it eventually, through the determination of one man who believed that the law meant something, that it had to mean something, or else nothing meant anything at all. And that, in the end, is what separates civilization from chaos, what separates law from tyranny, what separates justice from mere power. It is the belief, the insistence, the refusal to accept anything less, that the law exists to protect the weak from the strong, the innocent from the guilty, the just from the unjust. Henri Deschamps was protected too late, but he was protected, and that protection, that vindication, that acknowledgement of injustice created ripples that continue to spread, protecting others, inspiring others, reminding others that justice, however imperfect, however delayed, is always possible if someone is willing to fight for it.